Hello, everybody, and welcome again to another episode of the Risk Matrix podcast with myself, Dr. Martin, and James Junkin. Hello, James.
Hey, Dr. Martin, guess what? Happy birthday to me. Happy birthday to me. 53, baby.
Oh,
Made it.
50. Yeah, you young. You young.
You know, I
Happy
never thought
birthday.
I'd live this long, but since we have, I want to do another 53. That'd be cool.
Well, if you got longevity in your family, you just might have that chance. So, today, James, as always, we're powered by Veriforce. And we just came off the NSC conference in Denver. Hope y'all had a chance to stop by booth 3100, say hi to the Veriforce people, our strategic advisory board members, get your book signed by Dr. Daniels, and all those good things. I hope you did some really great professional development. James, have you heard from anybody that went to the conference?
Yeah, I heard it was a fantastic time. A lot of sharing, a lot of great vendors there. A lot of people. I hate I couldn't go this year. But sound like a lot of people that we both know, colleagues were there presenting, a lot of great presentations, a lot of takeaways, tremendous energy to bring workers home safe from hazardous jobs. So I always like going to the conferences. I had a conflict this year, couldn't make it, but hey, got ASSP's PDC to get ready for next year. Looking forward to it.
That's right. Hopefully you submitted an abstract for that.
Couple. Oh, while we're talking about that though, we will be at the OSHA Oil and Gas Conference in Houston. Several members of the Veriforce team will be presenting. I will be presenting alongside a colleague, David Bates, who's a former OSHA area director, and Brett Kettlecamp, who's an attorney at Ogletree Deacons. All three of us will be performing a mock informal conference. So
Very
what to
cool.
do when you get in front of OSHA's area directors in an attempt to settle a case. So
I
we
bet
think that'll be great.
that's going to be a really good presentation. So hopefully everybody can catch you there if they're going to the OSHA Oil and Gas Conference. So let's rip right in here. We've got a hot topic or rip from the headlines, and I'm going to let you introduce it because it's got to do with you.
Well, I'm a small part of it, but in September's issue of Professional Safety Journal, Brent Kettlecamp, the attorney with Ogletree and Deacons that I was referring to just a moment ago, member of our Strategic Advisory Board, he and I have an article uh, written from a safety practitioner's perspective and from that of an attorney related to the limits of standard indemnity and hold harmless agreements. Everyone, as part of their risk management strategy, right, has insurance, whether they're self-insured or use some third party, and then some type of contract between them and their vendors, be it a hiring client and its contractors, a contractor and its subcontractors, etc. So we wanted to explore how those particular agreements have stood up under the scrutiny of courts and identify what the limits are so that people can look at it more holistically from a risk management standpoint. And what we found, you may find very interesting, is that just the contractual language enough by itself is usually not enough to protect people from liability when it comes to worker injury cases. So
Okay.
subcontractor employee to contractor, contractor worker to hiring client.
I don't
So
want you
check
to
it
steal
out.
your
It's
own
over there
thunder,
in
James.
ESJ. Hmm?
I don't want you to steal your own thunder or Brett. So we're gonna have him on. So let's give them that teaser. And I think it's going to be a really good discussion because I think it's something that people don't really think about.
Well, hopefully we can have him on here in the next week or two. Follow up to that. Spoke with him this morning, so maybe next episode or definitely the following episode we'll have Brent Kellercamp on to come in. And I always enjoy talking to Brent because he's an expert in the legal aspects of occupational safety and health, and that's something that all of us as safety professionals can improve on. Which kind of brings us to our discussion today.
Okay. Also in professional safety, This is our discussion today. There was an article on heat stress called "The Heat of the Moment: Recent Litigation Regarding Heat Stress Injuries," and that was written by Matthew Arvin. Is that
Yes,
right?
yes.
So this is something that you forwarded to me. It's been a hot topic around.
Pun intended, of course.
Yeah, an unintended pun, uh, but a pun just the same. Uh, it's been a hot topic in circles for over a year now, right? The current state of federal heat stress regulation is kind of at a stall point, if you will. It's been put out there, right? Heat illness standard to protect workers from heat stress and all the different things that they can succumb to when working in the heat. OSHA has a proposed rule, but we have significant delays and litigation, right?
Particularly at the state level, some at the federal level. But this is a big issue. I don't think anyone should deny the impact of heat on workers in the workplace. In the cited article, uh, 436 work-related heat deaths between 2011 and 2021.
Right.
436 people. That's a lot,
Yep.
especially when we talk about over that period of a decade so that rounds out to 40 plus workers dying of some type of heat exposure um, in the workplace. So I found this article very interesting because you've got 5 states that have plans that are out there and they're putting forth their heat plans. Most of which are based in some part on California's Cal-OSHA's heat standard. You've got this proposed rule that seems to have stalled that may not actually be something that OSHA pushes forward, although, as we've seen, they haven't clawed it back.
Well, I think it may
There's
be
been no
called.
announcement. I mean, they had a list this long of the standards. We did a podcast on it on the things they're clawing back. Heat wasn't on there, which I was very surprised. I don't know about you. Were you surprised?
Well, I mean, I'm not surprised. Just because they didn't say they're clawing it back doesn't mean that they're going to push it forward either, right? And I think that that's the gist of this article is that we have 5 states that, because of the lack of federal heat stress standards, they're promulgating their own, right?
Right.
Which is their prerogative. You can talk a little bit more about the law that's involved in that, but where the federal stays silent, what the
Well,
states the
when,
states
when
are taking into their own
the states
hands.
are taking the initiative, at least 5 states are, and there are cases working their way through the court system. And there's already been some decisions made related to areas such as acclimatization, indoor outdoor work, uh, whether or not there's overreach. That was one of the cases that came out of Oregon OSHA. Uh, the plaintiff said, hey, the state, Oregon OSHA, is outside their authority and trying to supplant what the federal should be doing. That claim, that is sort of a due process claim, it looked like that got rejected. But there's a lot of these cases that are interesting to me because from these cases that you're going to find which way the courts are going to allow us to go when it comes to heat stress. Now, all of us can agree on we need to protect our workers. What you don't
I'm
agree
gonna
we need
say
to protect our
I'm gonna
workers
say
on heat?
most of us can agree on how we're gonna protect our workers from the heat, right? A lot of these standards, what they include are like water, rest, shade, rest breaks, climatization, etc., right? As safety professionals, I would agree with you that yes, we can agree that this is a real problem. Now, when it comes to actually implementing this on job sites, and I see this in construction, right? Productivity and cost, labor costs, etc., to get a job done sometimes preclude employers or encourage employers not to do these things that are quote unquote what we think is the right thing to do, right?
Well, I think most of us can agree that protecting our workers is a good thing. Obviously, 436 people dying over a 10-year span, somebody's not agreeing with us on that. But the how we go about protecting workers in the lines of things that you just said, acclimatization, water, shade, what does that mean? So you actually had a case come up in Cal-OSHA where the original standard, if you remember, there was an outdoor um, heat illness prevention standard, and then all of a sudden it popped up indoor heat illness prevention standard. Well, that indoor came out of a court case related to uh, transit authority having buses that did not have air conditioning in it.
Hmm. That's
And
interesting.
so when they were cited, their defense in this citation was your authority, your regulation was indoor. We're not indoor. We're inside the vehicle. Uh, and you know, the whole thing was we're not an outdoor space, right? We're 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 in a vehicle. We're not outside working in a field. Then therefore you're exceeding the authority of what the standard says by applying to us. And of course, this is in California. Sometimes very broad interpretations of what the law is. But I found it very interesting that what the court held in that case that shade must be provided to allow the body to be cool, whether it's an indoor space or an outdoor space. So what does that really mean, shade, to protect the workers? Uh, Another interesting case that came out of Cal-OSHA that I find this in assessments all the time. I don't know if you find this as well. When we start talking about training of workers, training of supervisors. Cal-OSHA is very specific in what it requires supervisors to know when it comes to heat illness prevention and what workers have to know. And what I see in a lot of the training, it just says company must train workers on heat illness prevention, right? Heat's hot, you need to stay hydrated, you need this. And in this particular case, that rose up under Cal-OSHA in 2022, the court held you have to be more specific. It needs to be company specific on how exactly you're going to do that. And too many times, like we see in other areas of occupational safety and health, the training is very generalized. It's not specific enough to the organization.
It's not specific enough, or it's not comprehensive enough, right?
Right.
As you said, we can't just say heat's hot, the sun comes out. Sometimes it gets to be 90 and 100 degrees. Make sure you don't overexert yourself. It needs to be very specific about the tasks that you're doing, the types of environment you're in, like you talked about indoor versus outdoor. I have done work for a company that did projects in Tampa, Florida. In Tampa, Florida, it gets really, really hot. It might be really cool in the morning, but by midday, it's super hot. And if there's not air conditioning inside the building, we can have just as bad a heat stress and heat problems as we do outside, right? And they're different. So comprehensive means looking at all those different variables and putting together a plan that works for each specific instance.
Absolutely. Absolutely. Uh, there's just been a lot of litigation in California over this. And so I encourage people to check out the article, a lot of detailed research in here, written in plain language where all of us can understand. Uh, I thought it was very well researched, uh, cited properly with a lot of application to organizations. There was another case, Rios Farming Company, and 2023 that worked its way through the courts in California. And the issue there was it was in an agricultural setting, but the water was placed at the end of long rows, right? And the court said traveling that far to get access water in itself was a risk, and it really violated the standards intent. So I also found that issue, particularly out of California, the courts are looking at what the intent was, not just the black letter of the law. Well, what did we mean for you to do, right? And so the lesson is common sense. Water needs to be close to the workers. They shouldn't have to have a lot of physical exertion to get to the water source that's supposed to keep them hydrated, protect them against the heat. But here's the one that probably most people are looking at, because California affects California, Cal-OSHA, etc. How this has been going in the federal courts under the general duty clause, because we don't have a federal standard. OSHA will cite you for failure to protect your workers from the recognized hazard of heat under the general duty clause. Okay? And so OSHA cited USPS, the Postal Service, right, in 5 cities for exposing workers to heat stress under the general duty clause. Now, when this went to court, what happened was the court vacated all of OSHA's citations because they said OSHA failed to prove, number one, that a hazard existed and that feasible abatement methods were available. So, that's contrary to what OSHA's position was in that situation. But
we can debate that, right? I think you can identify that the hazard did exist. I'm not arguing with the courts because I'm not a lawyer and I'm a judge, right? But I can see where OSHA came from with that, because I think heat is obvious.
This was the initial, right? This is the administrative law judge, right? It says here he vacated all citations saying that OSHA failed to prove that a hazard existed and that feasible abatement methods were available. Argued that USPS's work shifts weren't prolonged exposures and workloads weren't strenuous enough. Then it went to the review commission. All right. The review commission reversed the administrative law judge, and it disagreed with them on the hazard presence, and it cited expert testimony and scientific studies, and it upheld the ruling on feasibility grounds, noting that the Postal Service's complex logistics and union agreements made the proposed changes impractical, and that OSHA failed to prove economic and technological feasibility of rest breaks and acclimatization. So there's just a lot going on with these heat stress cases.
Right.
What's the final impact for you in your state when it comes to things like acclimatization? What does that word mean? So OSHA in the federal has decided to say what acclimatization means, right? In the proposed, you can work so much in this, so much of that, right?
But so what I'm going to say, James, right?
Mm-hmm.
It just depends. Acclimatization just depends. It depends on the area that you're working in. It depends on the tasks that you're doing. You can make generalizations, but there are things that fall outside of those generalizations in which companies and or when we have some of these cases that come up, OSHA or the administrative law judge or the OSHA review commission are going to have to decide and set some precedent.
And so you see in other states, state action in the state legislatures to prevent enactment of local regulations enacting heat stress or heat illness prevention laws. Texas House Bill 2127, that preempts local ordinances like water break laws in Dallas and Austin, where they're trying to enact some of that. Florida's got something, right? And the Florida, under their House Bill 448106 from 2024, that's designed to prevent at the state level from local municipalities creating their own heat illness prevention laws. Then you've got this whole thing in the federal rulemaking situation, uh, I don't
So
know,
what
you know, you got this thing with Trump and these executive orders, right?
Yeah.
So on one hand, you had this OSHA proposed heat rule that they have not clawed back. But on the other hand, you've got Trump's rule executive order that says for every new regulation, 10 got to come off the books. So right now,
Well,
no
which is
one's filed
interesting for
anything
OSHA,
because
right?
they're not.
I mean, if I'm gonna take stuff off the books, I can think of a lot of stuff I'll take off the books in favor of things that are sticky, stuff that's killing workers, right?
Well, I
And
100% agree with a heat standard. I wasn't opposed to an ergonomic standard. But let's be reasonable. Let's be prescriptive. Let's be clear at what we want workers and companies to do.
so
Uh,
so I think you got a better chance with the heat standard than you had with the ergonomic standard, because I think it's very hard to be prescriptive when there's such a wide range of body types, sizes, etc., that go on when it comes to ergonomics and how ergonomics affect people, pre-existing conditions, etc. However, with the heat standard, I think that you can be more prescriptive, right? Because in general, apart from some, medical things that people might have going on, you can you can come up with some generalities, right? And most things will fall within that 95, 99%
yeah,
uh,
but when you work here and
application.
you say, okay, if the temperature is above 80 degrees, we have to give workers break every 45 minutes or whatever that's been out there and being proposed.
I'm not saying that's
That's not
reasonable.
reasonable,
I'm not saying that's reasonable. I'm saying that when you have the I think you can be more prescriptive, but you have to be
right?
reasonable in those prescribed situations, right? So I think we can both agree. I mean, I've worked in 80-degree weather. I'm sure you've worked in
People
80-degree weather. What? I think
lost it
we
there
can.
for a second. Yeah, I mean, I think we're saying the same things. Here's what I want OSHA to do. Speak and be specific. Tell us what the rules are, right? So we can follow the rules. But when we make rules, they need to work for everybody. So when you say you want an acclimatization period, let's define what that is. Okay. Let's go ahead and address. Well, if worker A worked for a contractor down the road, my competitor, and he just came from him and worked for me, do I still have to do an acclimatization period? Meaning they can only work 2 hours this day, 2 hours the next day. So we build up 2, 4, 6, 8 till we get to a full day's work at the end of the week. Okay, who's paying for that? Do we have to pay the worker for that full 8 hours, in which they only perform 2 hours worth of work? You know what I'm saying? Be prescriptive. Tell us what the rules are. Because here's the thing: while we're having all these debates and trying to figure it out and having extremes and being unreasonable in certain positions, 436 people died.
Well, I hope we can agree on this. I think we're better off with the federal law, a federal standard, than we are with all kinds of wiggle room in the states, right? Some saying workers matter when it comes to heat related illnesses, and some basically saying we're going to prevent you from doing this because it's not economically feasible. That's my opinion. I think we're better off with a federal standard than we are hashing this out on the state level.
I would agree with that. I've always kind of felt that anyway when it comes to some of these state plans. Uh, Not totally against state plans. They can address local concerns. They have to meet the federal standard in a minimum. But this is going back to trying to define outdoor places of employment, right? This ended up in a court case trying to decide whether a vehicle that doesn't have air conditioning meets the definition of an outdoor place of employment, right? And so that citation comes down. The transit company says it's not outdoor, it's inside a vehicle. And the court then has to come and say, Non-air conditioned vehicles used during extreme heat qualify as outdoor workplaces. Okay. What does extreme heat mean? Be prescriptive. Tell me what that means, because extreme heat to you in New Hampshire is Christmas
Not
in Louisiana.
It is Christmas in Louisiana, for sure.
So anyway, if you're looking for guidance on this, you want to dig into it. I think the lessons learned, at least initially, is make your training be prescriptive for your organization, specific to your organization, as to what the expectations are, what the rules are. Don't use generalized training when it comes to heat stress, particularly in these states where they have state plans. Don't make it super difficult. Be reasonable, right? If I'm going to be in an agricultural setting and I'm just trying to comply with the law and not taking my workers, it is unreasonable to put a bucket of water or a cooler of water
Half a
5 acres
mile away.
away for somebody to have to hike to. Come on, man. Remember, this is about saving lives. Heat, stress, heat exposure is real. There's almost between 40 and 50 people a year have died over the last decade. So I really appreciated this article and August
Got some
issue
good
of Professional
information in it.
Journal. It's been reposted many times. It's been reposted on my LinkedIn page, and I think we probably put it up on the podcast page as well. Maybe some people come take a look at it like that. Don't know what all the rules are about reposting it, but I shared it
Yeah,
on my
be careful.
LinkedIn.
Be careful. So I will say you probably can get professional safety if you join ASSP. It's part of your membership, and I know that if you have available services, library privileges, you can get it through a lot of libraries. And I just want to
I
circle
think it's
back.
also posted on the ASSP's LinkedIn page. You might have to just scroll back, find it.
Okay. Well, and I just want to circle back, James. Your article with Brent Kettlecamp that you're going to talk about in the coming weeks is in the September issue, right?
September issue of Professional Safety Journal.
So
It's a checkpoints article.
if you want to prepare for that discussion with James and Brent coming up, you can pull that article from the September issue. It's a good article, and it'll prep you for that discussion with James. And certainly if you've got questions that you want them to address in advance, one of the places that you can put that, or several places that you can put that. One, you can put it on our Risk Matrix podcast company page, which is on LinkedIn. You can send it to James and I personally through our emails or through LinkedIn. You can post it on our Spotify account, on our YouTube channel with Veriforce. You can post it a bunch of different places. So if you have questions coming up, get those questions to us, because once you read that article, you might want James and Brent to address them when we talk to them about it on the show. So if you want to find us, James, where can they find us, and what should they do?
Hey, man, we got our own LinkedIn page now, baby. The Risk Matrix podcast has its own LinkedIn pages where we've got shorts of past episodes, upcoming episodes, things that we find interesting that we referred to on the podcast. We're also there, still on Veriforce's YouTube channel. You can go download us there on Spotify, on Apple Podcast, and there's a new one. I can't remember the name of it, but it's a very popular podcast. What is it, Amanda? There you go. Our lovely producer, Amanda, coming in from the bleachers there to let us know about it. Thank you, Amanda. Appreciate that. You can find us a lot of places. Hey, reach out, share with your friends. We do this for you. We'd love to have a great discussion around safety and techniques and methodologies. We may not always agree, but the one thing we can always agree on is this: we all want to get workers home safe.
So in closing, we got two things to say to you. One, it just depends, and
happy birthday, James. Roll Tide, baby.
Roll Tide, baby.